have Mr. Bilal as well as Mr. Gajappo appearing for the state. Here on, for defendant's motion for release on his own recognizance or in the alternative to set reasonable bail. We also are on for our first status check trial readiness. First of all, let's address the status check trial readiness real quick. I hesitate to ask, but how are we going on discovery?
We got a substantial amount of video statements, reports. We've been going through that. We haven't met yet. I would like to meet, do a file review, and make sure we do have everything. But just to be honest with the court, June is ambitious. I'm not ready to say that we won't be ready for June. But just the amount of stuff and what's left, I just want to let the court know that it's going to take a lot to be ready by June.
Understood.
Are you having any love? Are you getting any loving? If other people do, why can't you have any?
Mr. Gajappo, where are we at with discovery? I don't have any cases that are quite this discovery, have this much discovery over this many years, over this many detectives, etc.
The original discovery, what we had at the time of the indictment, has been supplied to the SBA, and I believe it was complete. Since that time, we've actually gotten quite a bit. In fact, the number of the exhibits attached to our opposition came in shortly after our receipt. So there is additional discovery to provide them, and I also anticipate that there will be even more discovery required between now and June.
Okay. So I think it's safe to say we're working on it.
Correct.
All right. We'll do another status check, maybe 45 days. Does that work for the parties? Regarding trial readiness? Okay. That deal be?
That's February 20th at 9 a.m.
All right. Now that that's been dealt with, let's move on to the defendant's motion for release as a recognizance or an alternative to set reasonable bail. Mr. Arroyo, it is your motion. I did read your written motion as well as your reply. Anything you wanted to add or anything you want to highlight at this time?
Yes, Your Honor, I'm not going to rehash everything in, but there's some things I did want to highlight for the court.
Of course.
I know this court's got two separate decisions to make, whether or not Dwayne should be denied bail outright. If he is granted bail, is that a monetary bail or is there something that's restrictive, such as electronic monitoring, house arrest? Today we are asking Your Honor to release Dwayne on house arrest on electronic monitoring. As we said in our motion, he's not a danger to the community, he's not a flight risk. And I think the overwhelming thing, the question that's looming out there is, if Dwayne is so dangerous, if this case is so overwhelming, his guilt is so overwhelming, what's been happening for 15 years? Why did we wait 15 years to make the arrest? The state has attached his 2009 statement to Metro. They attached the proffer to this court. They've been taking the position that he has no immunity, that they can use the statements against him. If that is their position, then why wasn't he arrested in 2009? At the earliest, I mean, we know that he spoke to Metro. And
I think the state has said that the proffer is admissible. I don't think that we've got crossed that bridge.
Yeah.
But any additional statements, I believe, had been provided to this court, and I believe could be properly considered.
Yeah.
Is that
Well,
accurate?
While I was going to address the groups of Ms. Braden, and we'll address both the 2008 and the 2009 statements, as well as the reasons for why he wasn't arrested after making that statement in 2009.
Okay, sounds good. I'll let you guys do that at some point. I'll go back to you, Mr. Roy. I apologize for interrupting.
But, I mean, they did tell the grand jury that he did give a proffer in 2008. They told the grand jury about that. They did say that in 2009, that Nevada hasn't promised anything. So that position, at least since 2009, this information has been known to Nevada. I think what the problem is, there's really no cooperation. There's no gun. The white Cadillac was never found. There's nothing to corroborate anything that was said in Dwayne's statements. I also believe, like I said in the motion, there's problems. They rely heavily on what was said in the book. The author was never called to the grand jury, so we don't really know what parts are Dwayne's statements, what parts are the author's statements, what's been dramatized for purposes of the book. So we really we're missing this lack of corroboration of the statements. The state does try to address this corroboration issue with Devonta Lee at the grand jury, as we said in our motion. He is not a credible witness. He was interviewed several times by the authorities. The grand jury wasn't told this, but he did previously say that Big Dre is not the shooter previously. He was specifically said, I asked Dre, and Dre said he's not the shooter. That's why the statements of police were before the grand jury. He told the grand jury he was in jail, or back up, he told the police back in 97 or 2007, 2008, that he's never seen a white Cadillac. Then he told the grand jury, oh, I did see a white Cadillac. But then he also told the grand jury, well, I was actually in jail at the time all this was happening. So he lacks all credibility. And he's inconsistent in his own testimony. They also try to connect this with Malcolm Greenwich, who was in the car behind Mr. Shakur at the time of the shooting. And they say, well, Devonta Lee's allegation that Big Dre is the shooter is corroborated by Malcolm Greenwich's testimony at the grand jury. But if you look back at what Greenwich said at the time of the shooting, just hours after the shooting, and I did not attach this to the motion, but at the time of the shooting, Greenwich said he couldn't see what type of arm was out of the car. The grand jury, he says it's muscular, but previously he said he couldn't see it. It happened so fast, all he saw was a black arm with 2 people in the car. It's different from the 4 people that is alleged to be said by Dwayne. So I think you just have all these inconsistencies. You have these statements that have changed over time. And, part of the problem is this case has been tried on YouTube already. There's been so many interviews given, so many different stories thrown out in the public, that things change over time as people are picking up bits and pieces from these YouTube interviews that are out there.
Snoop, gin and juice, how'd you come up with this? See, this right here started with my great-grandfather. Calvin brought us the first.
We have something you might be interested in.
And Prince, how much of this can you get?
Much as you need.
I like the way that sounds.
One more thing. You should think about adding juice to it. I think the ladies will like that.
That's not a bad idea.
I think this whole YouTube narrative plays a part in this. I think there's concerns that Devonta leaves after his 15 minutes of fame. I did attach a link to a Vlad TV interview where the interviewer, Vlad, says, hey, Devonta Lee, I've been in talks with him. He's going to come on. He says, I actually talked to him way before I talked to Dwayne. But who's going to pay Devonta Lee for an interview that he's just saying the same thing that everybody else is saying? So now he's coming up with this counter narrative years after the fact, but when this actually happened, he said he doesn't know anything. One of the biggest issues also is, Suge Knight. The grand jury never hears from Suge Knight. I know the state says, hey, it's no secret Suge won't cooperate, but there's been no attempts to get him here. He's incarcerated in jail. He has no choice. They could have forced him or compelled his appearance here at the grand jury. And I think that the statement by that he's never cooperated, I don't think that's accurate. He does give a statement after the fact. In 1996, he gives a 30-page statement to Metro. He just says he didn't see what happened. So, this doesn't corroborate, it doesn't match up with what Dwayne's saying, or alleged to have said in the book. The book says, hey, we pulled up and me and Suge, we locked eyes in this really dramatic, intense moment. And Suge's saying, no, I didn't see what happened. All right, if this was true, if this corroborated, Suge and Dwayne know each other since Pop Warner days. He's gonna know if Dwayne's in that car. They should have heard from him. And he did give a statement. He has corroborated with Metro before. If this court is going to, find some of these statements that are credible and you are going to consider them, the statements don't support that Dwayne actually ordered the shooting. The shootings, the book and some of the interviews talk about they were going to meet up with Shakur to get the rematch, the one-on-one. And Anderson was jumped at the MGM. There was multiple members of Shakur's entourage, and it was just Anderson alone, right? So the book and some of these interviews talk about we were looking to go get the rematch, the one-on-one fight. They said when they pulled up along the car, it appeared that Shakur was reaching for a weapon. And the state says that no weapon was actually found, but in Nevada, you don't need to actually, find a weapon. There doesn't actually need to pull a weapon. Appearance is enough for self-defense. If they appeared that he was in danger. But I think here it's not far-fetched to think that Shakur had a gun. I mean, he was on parole, or he was on bail pending appeal. He's a convicted felon, sexual assault. He shot 2 off-duty cops. This was well publicized. He was just involved in jumping Mr. Anderson in the MGM while out on bail on one of the most crowded nights at the MGM. It's not far-fetched to think that he was going to commit an act of violence. In regards to dangerousness, I addressed this in the reply in depth because I was really worried when I saw this allegation that there was a green light. And that word itself is inflammatory, it scares people, and I think there was an issue that I was worried about was the media was going to pick up the word green light, and they did. And I put some of the headlines that have been run now saying, Dwayne orders a green light against witnesses. If you read what the state's actually alleging, they never say that Dwayne ordered the green light, because there is no evidence of that. If you listen to the phone call, there's actually no threats being made, right? He doesn't even mention witnesses. There is discussion about something that was heard on the streets, that there's a green light on our side. And Dwayne's asking what? He doesn't know what it's even being talked about. And I believe the correct interpretation of that is there's a green light on our family. There's word out there that our family is in danger. Not that, hey, Dwayne ordered a green light, because that's not supported by the phone call. I know the state has listened to every single call he's made since he's been in custody. If there was a green light order, it would have been submitted. He doesn't mention witnesses, let alone threaten any witnesses during the phone call in question. There was also allegations that Devonta Lee was moved because of this green light. I don't see any support for that. That he was moved because of this. As we say, it's pretty clear he's working with the FBI, that he's a federal informant that testified in one of the biggest cases, the most highly publicized cases. So it's not a surprise that the feds will step in and move him on that. But there's absolutely no threats from Mr. Davis towards Devonta Lee. And as we said, Lee is younger, he's a violent gang member. If anything, it's Davis and his family that should be worried about Mr. Lee. There was also an email addressing another witness where they said that I was going to give a statement to Mr. Davis' son, and that once the public knew about that statement, the witness was done. As I said in my reply, we're talking about YouTube. And I asked the court to Google the name and see how many interviews this witness has done. This isn't a surprise. It wasn't like we got this discovery, we're learning about stuff that wasn't out there in the public. This witness has been giving YouTube interviews for years, and he didn't even testify at the grand jury. But this is all about this YouTube world where all these people are coming in and they're giving these stories. And as I said, this isn't, I don't know if you're just familiar with wrestling, this is WWE, this YouTube life, this isn't real life. These people, Dwayne knows these people in real life. They have each other's numbers. If you look at the statement from Reggie Wright Jr., he says, hey, yeah, on these YouTube interviews, I talk bad about Dwayne, but hey, I have his number. I try to hook him up and try and get him paid on some of these interviews. I mean, these guys, Dwayne's 60 years old. These guys are old now. They're grandfathers. They're trying to do these interviews, trying to make money. Nobody's gonna click, nobody's gonna watch if they're on there reminiscing while at the park with their grandkids. Conflict sells, and that's what they're trying to do. They get on these interviews, they puff their chest, they're trying to get clicks.
Last summer felt like a dream. It was unlike any other summer. Watch me strut and watch me fly. Everything I want is outside.
There was also the witness list, and there was an issue with the witness list. I don't know if that should be characterized as a witness list. If you see how old that document is, it's from like 1996. It's a list of people that were raided back in Compton when this incident first happened. This wasn't any surprise to Dwayne. Dwayne knew everybody on there. Half of the people on that list aren't involved in the case. Half the lists are dead, or half Dwayne knows already. So this wasn't, the list makes it to his son, right? We don't know how it got there. There's an allegation that maybe his prior attorney gave it to him, which seems likely since it has the attorney's phone number on it.
Not his attorney.
Well, the person that was going to be his attorney before conflict was found. All right? But this isn't rare. I mean, all of our defendants want their families to have their discovery. There was no threats actually made. There's nothing on there where they just said, hey, go find these witnesses. Like I said, none of them were called to the grand jury. The majority of them aren't even involved in the case. This is a list from 1996, people that were raided in connection with the investigation back then. Listed out his medical conditions. He is, his cancer is in remission, but he does have heart issues. He's not getting proper treatment, proper diet, proper exercise, Your Honor. He is a father, a grandfather. He has support of his family here today. He had more people here last week, but this wasn't considered on my request, but he had a lot of family in from California last week. He does have support. He made an oath. He did give that interview with federal authorities in 2008. He made an oath to walk away from the life. If you listen to that tape that was provided, he says, I'm retiring. I never thought I'd say this, I'm retiring. I'm giving up this lifestyle.
Doesn't he sustain a parole violation in like 2016, 2015?
The state puts that in their opposition. I don't have any indication that he went to prison in 2015, 2016. I know that was around the time he was having surgery for his cancer.
We provided the judgment of conviction in discovery for his conviction for a felon in possession of a firearm. He was arrested with both drugs and firearms. Was convicted from a 2013 arrest to 2015 conviction in California.
And was he incarcerated as a result?
I believe he did about 6 months on a 2-year sentence.
Understood. Okay.
Alright, there's no connection to this gang life or anything that they're alleging. Your Honor, he has been employed before he got sick, before he got the cancer. He was making an honest living. As I said, now he is at home with his family. Before he was arrested, he did not flee. He knew this was coming down. He got the Markham notice. He could have ran if he wanted to. He's been under investigation throughout his life, talking to the federal authorities, the Nevada authorities, California authorities. He's never ran. There's no evidence that if he is released with bail or monitoring that he is going to flee. He will return. If he was going to run, he would have did it back in the summer when he was served with the Markham notice. So,
Thank you, Mr. Arroyo. I understand your request. State, I'm going to turn to you to address the issues that were brought up, including the lack of corroboration, and the fact that, we're taking his statements at face value. They include some sort of baked-in lesser charge.
Yes, Your Honor, just so the court's aware, I was planning on handling the primary argument, and then Mr. Giacomo was going to deal with the supplement that we thought regarding the major extension. That's the picture for it.
So you're going to address if there's proof evident, presumption positive, as well as the majority of the factors. Mr. Giacomo is going to address bail factor 6 or 7.
Right, yes.
Okay,
Great. Your Honor, in listening to defense counsel's argument, one of the things he said is there are all these inconsistencies, but there is one constant, that Mr. Davis has consistently admitted to being the architect of the murder of Tupac Shakur. The state's position is that the proof is evident and the presumption is great. Now, there's reference to this case being 15 years old in terms of the statements, but the 2008, if you listen to it, is clearly a proffer, right? It's not immunity, it's a proffer, meaning that we can't use his statements outside of that room unless he disavows or says that he was lying in making those statements, which is what precisely what happened here in the defense's moving case. But in 2008, we certainly couldn't have filed charges based on the 2008 statement. In the 2009 statement, we were unclear, in perfect candor of the court, of the circumstances surrounding that statement. Frankly, until Mr. Giacomo alluded to the fact that we're getting more information now, even post-indictment, we got more information regarding the circumstances surrounding that statement only in the last few months. Clearly in the statement it says that you're not being promised anything. However, there are an abundance of caution. We could not proceed just based on that.
Damn, why?
No, we didn't even submit that to the grand jury. We didn't submit that statement to the grand jury because we were just had some concerns that I think have been alleviated since then, but there were some concerns. So there's no immunity. There's this notion in the cases that this is all for entertainment, and I think if you listen to the 2008, 2009 statement, you clearly hear that this is not for entertainment. I don't think that's true. So this court asked me about corroboration. Well, the first thing is that in any instance where we've had somebody confess to a murder, you usually don't have to corroborate with great detail their confession, but there is corroboration here. First,
What y'all think about Keefe D, man? I'm about to do a video on that. Y'all stay tuned. I'll be back in a jiffy.
Leader of the Southside Compton Credit School, that's corroborated.